Our first case this morning is Heien versus North Carolina. Mr. Fisher.
Mr. Chief Justice, and may it please the Court. In a country dedicated to the rule of law, governmental officers should be presumed to know the law at least as well as the citizens are. That being so, when questions about individualized suspicion arise under the Fourth Amendment, they should be addressed against the backdrop of the correct interpretation of the law, not simply any plausible reading an officer might have.
So suppose that this state, North Carolina, did have a good faith exception to the exclusionary rule. What would you be arguing today?
We would still be arguing, if that were the case, that not only the Fourth Amendment was violated, but that the good faith exception didn't apply. But you wouldn't have to reach that question in this case, and I would concede to you, Justice Kennedy, that would be a debatable argument. Under
Why would it be any more debatable than the argument you're making here? I more or less anticipated your answer. I think that has to be your answer. I think you have to tell us, even if the good faith exclusionary rule applies, a mistake of law just doesn't count.